Okay, so we just talked about res judicata and the concept of how you're only supposed to get one shot at any court case, right? So with that in mind, you have to make sure that the witness is going to either verify your claim or deny the other person's claim. So the witness, in a sense, is one of the key components to any case. They're the individuals who are going to give firsthand knowledge of or firsthand testimony about a particular situation. So, in essence, I would say the witness is your responsibility. It doesn't matter if it's a civil case, it doesn't matter if it's a criminal case, it really doesn't matter what type of case it is. But if you're relying on a witness to prove your case, then the witness is going to be your responsibility. Is your responsibility to keep up with the witness? Is your responsibility to make sure you have that witness ready in court? Now, I can imagine there are going to be witnesses who don't want to go to court. They may not want to testify for several different reasons. But again, that doesn't relieve you of your responsibility to get what you need out of the witness. For a witness that wants to testify and wants to give testimony, that is, in my mind, is a very simple situation. You're basically trying to get that person in court so that they can testify on your behalf, right? To help you prove your case. But there's going to be situations where the witness may not want to testify, or there are going to be situations where the witness may intentionally testify and lie. They may lie when they get on the stand, or they may even lie when they have the interview with the investigator or the police, right? So if you encounter a witness who is lying during the investigation, it's your responsibility to detect whether or not this person is lying and to figure out where your strategy is going to be once you get them into court. There is something known as impeaching a witness, and I actually spoke about it, or actually debated about it with, I actually spoke about it in another video where we were talking about witness testimony. I can't remember the name of that video. But basically, you can impeach the witness, right? Which basically means you can treat that witness in a hostile manner when that witness is on the stand so that you can extract the information you need, or so that you can basically attack the credibility of that particular witness. So, with all this in mind, you have to do everything within your power to, number one, interview the potential witness, and then number two, make sure you get that witness in court. And if the witness decides they don't want to come to court, then you have tools at your disposal. But no matter what happens, you have to realize that the witness is your responsibility. You're trying to litigate a case, you're trying to sue someone, or you're trying to avoid going to jail. In those situations, or even if you're trying to prosecute someone, in all those situations, the witness is your responsibility. Sometimes it's responsibility of both the plaintiff and defendant, or the prosecutor and the defendant. Usually a witness is going to either help or hurt a particular case, right? So since we're talking about prosecution, right, and we're talking about how you only get one shot at a criminal trial, that's the context of this video. We're going to take the responsibility of the witness and place it squarely in the hands of the prosecutor, because they need their witness to come to court and testify, right? Without that witness, then their case is weak, right? According to some of the people that are making these allegations, right? So with that in mind, understanding that the witness is the prosecutor's responsibility, the prosecutor has several tools at their disposal. I've already mentioned one. They can impeach the witness. When the witness gets on trial, or when the witness comes to court, they will realize that the witness is lying, and it's their responsibility to, number one, detect what type of witness they're dealing with, and then number two, have a game plan for when you get the witness on the stand and the witness starts saying some erroneous stuff or just flat out lying, right? So impeaching the witness is one of the tools at the prosecutor's disposal. Another tool at the prosecutor's disposal is subpoenas, right? Again, you're going to have witnesses that want to come to court, they want to testify, they want to get this information out there, but you're also going to have witnesses out there who don't want to participate, or who, when they do participate, they're going to try to sabotage the case. That's for the prosecutor to deal with. You can't make the excuse that, oh, well, the witness wasn't available in the last trial, so we're going to bring up some new charges to get an excuse to hear the case over again. No, you can't do that. We've already covered the concept of only having one shot, or one bite at the apple, as they say, right? So one of the tools that prosecutors, and one of the tools that any litigator has, is a subpoena. But since we're talking about prosecutors, we're going to basically say that prosecutors have the power to subpoena and examine witnesses, right? And this is going to be an Illinois statute 215, Illinois Civil Code and Procedure 5403, right? And basically, it just goes on to talk about how the prosecutors can examine any person under oath, how they conduct a particular business or conduct affairs of a company, or how they conduct their own affairs, right? And it talks about what happens when a person fails to obey a subpoena. If a person fails to obey the command of the subpoena, and they don't have any excuse and they don't have any reasoning for disobeying that command, then what can happen is that they can end up being fined up to $2,000. And this is in the state of Illinois. The other thing that can possibly happen if they fail to obey a subpoena is that they can actually end up going to prison, right? Or they can be in prison, rather, right? They can be in prison in the county jail, and they can also be fined. So the prosecutor really has no excuse. And as we get more and more into this particular video, you're going to see why, right? They have no excuse, because if a person is refusing to show up to court, you can issue a subpoena against them, right? And the subpoena is going to demand that they have to show up in court, right? So, and we're going to get into why it doesn't matter where you are, right? The only way you could potentially avoid a subpoena is if you're living in the place where they don't have courts, right? So, and we're going to get into that in a second here. So, you're probably thinking, what if the witness decides to leave the state of where the case is actually happening? Or what if the witness was never in the state where the case is happening to begin with? Or what if the witness leaves the country? What if the witness leaves the country and they basically jump up and just move to Italy, or go to Italy for an extended stay, right? So, as I'm going to explain shortly here, none of those are excuses or reasons that's going to give a prosecutor the ability to refile this case or recharge a person because the witness decided to move to Italy, or it was in Italy, or the witness is in another state. And the reason the prosecution doesn't have the ability to make this excuse is because of something called the Uniform Interstate Depositions and Discovery Act, right? And this is in Illinois, 735 ILCS 35, right? And it talks about issuing foreign subpoenas, right? And then basically, according to this act, it doesn't matter where the person is, if they're in Puerto Rico or if they're in California and the case is happening in Illinois, or maybe they're in Italy. then they can issue a foreign subpoena, right? And a foreign subpoena, the way it works is that they write the subpoena in Illinois, and then that subpoena is transmitted to the jurisdiction of where that person is basically staying. So, in a case where a person is in Italy, for per se, then the prosecutors in this case can issue a subpoena to the court system in Italy, and then the sheriffs or whatever you call those people in Italy, they can then go out and deliver the subpoena to the person or persons in Italy, and that subpoena is going to tell them that they need to come back to the United States so that they can testify. Once that subpoena is delivered, then the people or the persons are obligated to basically participate. Now, you can get into some probably hairy situations, as I can imagine. Like I said, I'm not a lawyer, I didn't go to law school, and I've never had a criminal investigation. There are some situations where if the person is a citizen of Italy, they could potentially ignore the subpoena, or they can go through their justice system to say, hey, I'm not going to the US. I don't want to go. Uh, these are United States laws and they don't apply to me. Something like that could potentially happen. I'm not 100% sure. This could be a topic in and of itself that I'm pretty sure most legal scholars probably won't even work out. But nonetheless, if the person is an American and they decide to jump up and go to Italy for whatever reason, then they can be subpoenaed. And if they don't come back for the court hearing, then or a deposition, they don't necessarily have to come back to court. It could be a scheduled deposition, right? If they don't come back for that, then there could be some very serious consequences if they are actually a United States citizen. We're going to get into that in a little bit. But first, let's talk about the fact that there is also a federal subpoena process for foreign jurisdictions. So, in a situation where the federal government decides it needs to get involved because, hey, it decides there could be something going on here, perhaps a conspiracy to defraud the United States, the federal government also, at that particular time, has the power to issue a subpoena. Basically, the tool that they can use is 28 USC 1783, subpoenas of persons in foreign country. And then it basically reads: a court of the United States may order the issuance, of a subpoena requiring the appearance as a witness before it. They may basically require a national or resident of the United States who is in the foreign country to basically come back to the United States and answer questions regarding a particular case, or to produce documents, videos, so on and so forth. So as you should slowly start to see that there really is no excuse for trying to ask for a second trial, and mostly because in the first trial, all the tools were available for the prosecutors to basically get the witness in the court. And then if the federal government at that point felt that there was some hanky panky going on, they could have gotten themselves involved and issued a foreign subpoena to a different country, so on and so forth. So again, I just really want to drive home the fact that you only have one trial, but there's tons of tools that prosecutors have at their disposal that they can use to basically try to prosecute somebody. So again, I just want to reiterate that the prosecutor has some very good tools at their disposal for getting the witness into court to testify, and they also have tools at their disposal for dealing with witnesses who don't testify truthfully, right? So there's no excuses, there's no reasons for trying to retry something a second and third time, because the witness weren't available, right? So I really just want to drive this point home because it's going to matter at the conclusion of this video, right? So basically it goes on to say, so I'm looking at 725 ILCS 5, which is going to talk about things we've already talked about, but we're going to go in depth. And it basically says a witness who is duly subpoenaed who neglects or refuses to attend any court under requisition of a subpoena shall be proceeded against and punished for contempt of court. And then it goes on to say attachments against the witness who live in a different county from that where they're subpoenaed is returnable may be served in the same manner as a warrant are directed to be served out of the county from which they were issued, right? So now it looks like the prosecutors have even more tools at their disposal. Not only can they subpoena them, but they can also issue a warrant out for the witness arrest. And basically, this would entail the witness being arrested and taken to the prison or to the local lockup and held in place until it's time to have an actual court hearing. So, in my mind, if you think your case depends on a particular witness, there's no need to proceed because you can basically have that witness subpoenaed, and then if the witness doesn't show up, then you can basically have the witness arrested. But for the most part, you don't need to go to trial unless you have that witness. So to me, it looks like going to trial without the witness is a choice that the prosecutor makes or can make. And if they decide to go to trial without that particular witness, then the concept of the final judgment applies because you had a choice. You could have waited to have the witness arrested, and then once the witness was arrested, you could have had the witness held, and then you can go to trial, right? But if you decide to go to trial without a witness, then that's a decision that you made, and you can't have another hearing, or you can't relabel the case or add additional charges so that you can have a second hearing and then bring the witness that you could have brought in the first trial, right? Especially when the case has spanned it over, decades, like, 12 years or whatever, right? So that's not the only tool that the prosecutors have at their disposal. They have other tools at their disposal, right? So another tool that they have at their disposal is 720 ILCS 531-4. And that's basically called obstructing justice, right? So obstructing justice and issuing a warrant because of the person failed to follow the subpoena are two different things. On the one hand, the warrant for the subpoena is just that. You're just issuing a warrant and you want them to show up to court. And once that person is apprehended, you're just holding them in place until there's some type of testimony, right? Now, obstructing justice is something totally different. Obstructing justice, you're actually being charged with a actual crime, and that is going to have consequences. You could do some jail time, there could be additional fees, but essentially the statute reads a person obstructs justice when with intent to prevent the apprehension or obstruct the prosecution or defense of any person he or she knowingly commits any of these following acts. But for the context of this video series, we're going to only read one of them: leave the state or conceal himself or herself, or possessing knowledge of material to the subject at issue, which he or she leaves the state or conceals himself, or if a parent or legal guardian or caretaker basically leaves the state, right? So there is no excuse. There is no reason to continuously go back and forth to court because you failed as a prosecutor to get that witness in court the first time. As we've already gone through, there is a finality to all cases. A case has to be over at some point. You can't continuously come back and forth to court for little petty reasons. Oh, well, I didn't have the witness. Oh, well, this person kept the witness from me, or he basically defrauded the government from interviewing that witness. That's not an excuse, because you have all these tools available to you to get the witness into court so that they can testify, right? So that's pretty much it for this video. Leave your questions and comments below. Let me know if you think it's okay for the prosecutor to ignore all these tools that they have at their disposal and then turn around and refile a case and just give it a different charge. Let me know what you think. Leave your questions and comments below. And honestly, if I'm an attorney in a case where they're deliberately refiling the case, claiming that they didn't have access to a witness, if I'm an attorney in that case, and again, I'm not an attorney to begin with, but if I were, I would ask, did you do any of these things, right? And if you did do any of these things, then why didn't the potential witness get arrested for obstructing of justice, right? Or why didn't the potential witness get a body attachment against them or warrant put out for their arrest? Why didn't all this happen? And why did the prosecutors at the time ignore these potential tools, right? So anyway, again, that's it for this video. Leave your questions and comments below.